Okay, Scott, if you want to start the recording. It is 5:15.
I believe that's the signal from the zoning administrator that we're to start the meeting. This is the October 19th, 2021 meeting of the City of Charleston Board of Zoning Appeals zoning. Present are Mr. Morrison, Ms. Grass, Ms. Richards, Ms. Vargas, Mr. Bennett, and Mr. Robinson. Present from the planning staff are Mr. Batchelder, Ms. Ashby, and Mr. Valentine. These proceedings are being recorded, and we ask that those who speak identify themselves for the record. We'll conduct this meeting in usual fashion. We'll first receive information from city staff about the application and their recommendation. If the recommendation is favorable and no one objects to the application, usually the Board of Zoning Appeals treats the matter as being uncontested and passes it as a matter of course. If, however, the city recommends against the application or there is opposition to the application, we treat the application as contested and hear from the applicant and anyone else who's in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We'll then make a decision to approve with conditions, or deny the application. The Board of Zoning Appeals zoning has the authority to do three things. First, to hear appeals to decisions of the zoning administrator. Second, to grant special exceptions, a fact-finding function of the board. And three, grant variances to the zoning ordinance if the application meets the hardship test outlined in section 54-924 of the ordinance. The board may deliberate and make a final decision on a matter by a majority vote of members present at the hearing and qualified to vote, provided that not less than a quorum is present and qualified to vote. However, an affirmative vote of 2/3 of the board members present and voting shall be required before a use variance may be granted. For a variance to be granted, the Board of Zoning Appeals must make the following findings. A, that there are extraordinary and exceptional conditions pertaining to the particular piece of property. B, these conditions do not generally apply to other property in the vicinity. C, because of these conditions, the application of the ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And D, the authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. Tonight we have one deferred item, that's number 5, 30 Ray Street, will not be heard tonight. Additionally, as we have done in the past number of meetings, we'll follow the procedures quoted in our hearing rules, allowing 10 minutes for the applicant to make presentation, the applicant and anyone in favor, total of 10 minutes. And the opposition will have a total of 10 minutes. And the rebuttal, according to our rules, is the applicant is allowed 3 minutes. The first item on the agenda is to review the October 5th, 2021 board minutes. Are there any motions for comments or any recommendations for any adjustments to the board minutes from October 5th? Hearing none, Mr. Morrison moves for approval, seconded by Ms. Grass. All in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett.
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. The next item on the agenda is B1, 284 King Street, 292 King Street, 93 Society Street, and 95 Society Street. Request a second one-year extension of a vested right that expires on November 6, 2021, pursuant to Section 54-962. Vested right pertains to a special exception granted under Section 54-220 on November 6, 2018, to increase the number of units in an existing accommodations use from 19 to 25 units in a GBA, General Business Accommodation Zone District. Mr. Batchelder.
This application to extend this vested right was filed in a timely manner, and the approval concerns this group of properties here at Society and King Street, and involves an accommodations use that would utilize the combined properties shown here, these three properties. And previous extensions were approved, and this extension should also be approved. It satisfies the requirements. There have not been any changes that would prohibit this use from being constructed.
There have been no changes to this application from that originally approved. Are there any motions?
Move approval.
Is there a second?
I'll second.
All in favor signify by saying aye. Mr. Morrison,
Aye.
Ms. Grass,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett,
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Item number 2 is 62 Church Street, Charlestown. Request a reconsideration of the board's decision on September 7th, 2021, to approve special exception for a two-story addition and lot occupancy variance with conditions in an SR4 single-family residential zone district. Mr. Batchelder.
So just to refresh your memories, on September 7th, we heard this request. It involves this property at 62 Church Street, and which is a residential property, and there was a proposal to construct an addition on the rear of the existing house that was going to require the variance for the increase in the lot occupancy of the building on the lot, and the special exception to extend a non-conforming building setback. The board heard this request and made the motion for approval with conditions that was approved, I believe, unanimously by the board at that meeting. And so these are just drawing the zoning map and other information about the property, but and this is the approval form listing the condition. The condition was that the approval was based on the applicant making best efforts to baffle or reduce the noise emanating from the generator and HVAC units that would be relocated up onto the roof of the proposed addition. So that is the decision that was made. The appeal for reconsideration was filed in a timely manner, and that is now before you. And I have slides of the application form and the information that was submitted by the applicant requesting the reconsideration, and also have slides that were submitted by the attorney, Mr. Walker, who represents the property owner at 62 Church, who requested this approval from the board on September 7th. So I have all that information in slides, and that concludes my presentation. I'll be happy to answer any questions the board has during the course of this discussion. And with that, I'll turn it over to the chair.
Is the applicant present?
And Penny, that would be Brian Hellman, correct?
The applicant, yes, Brian Hellman.
Brian, so Brian and Jonathan, did they both sign up to speak, or just Brian?
I think it's just Brian Hellman.
Okay. So we should promote him.
Hi, Brian Hellman here. I hope everyone can hear and see me.
Mr. Hellman, would you please allow Mr. Batchel to swear you in?
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please proceed.
Thank you, Mr. Chairman. Hi, I'm Brian Hellman, 105 Broad Street, Charleston. I represent Dane Neller, and the owner of 60 Church Street, Teresa Malhado, in this request for reconsideration of the approval that was granted on September 7th. And the position of my clients is that the board misapprehended and misconceived the questions involved and erred in its findings and on the disposition of this matter. And that was, there were 6 reasons why that was the case. And I'll run through them and what my client's positions are in each one of them. First, that persons who had received confirmation, Ms. Malhado and Mr. Neller, as having registered as opposition speakers and were noted as present, were not afforded an opportunity to be sworn in or to speak. Prior to the meeting, both Ms. Malhado and Mr. Neller properly registered to testify. Their presence and desire to testify was confirmed by Penny Ashby via email, though they were never sworn in or afforded an opportunity to testify. During the hearing, there were a number of Zoom-related computer issues in which I first could not be heard and then I could not be seen. And while experiencing those issues, I did notify the board that both Ms. Malhado and Mr. Neller were present. After those Zoom-related issues were corrected, I was the only one sworn in by Mr. Batchelder. And after that presentation, my presentation was completed, I was not able to speak to remind the board that Ms. Malhado and Mr. Neller were there. I was removed as a panelist and therefore could not let the board know that they were present with me and were prepared to testify and had properly registered. So consequently, I had no ability to let the board know that. They had no ability to testify. And we believe that denied them both of their procedural and substantive due process rights. Secondly, my clients believe that the board failed to consider the existing and future commercial uses of the property and only considered the residential use in granting the special exception and variance. At the conclusion of the Wallace's rebuttal, Chairman Robinson asserted the existence of other uses that are occurring on the Wallace's property and said that those were not before the board, that the board only addresses physical changes to the subject property, not other uses of the subject property. Mr. Batchelder concurred with Mr. Robinson. The first element of the, I apologize. The first element of the special exception test for this situation is the use of the subject property, 54-110F. The Wallaces in their response acknowledged that Mrs. Wallace did in fact work from the home as an interior designer. However, Mrs. Wallace is not, as evidenced by the FOIA request from the city of Charleston, the response from the city of Charleston, the responses, the results of which were submitted and filed with the board, showed that no application had been received or approved for a home occupation use as 54-211 would require. Consequently, the board erred as a matter of law when it determined the physical extension of the non-conforming use is limited to extending or increasing the non-conforming use then in existence at the time of the adoption of section 54.110 of the zoning ordinance, as both the interior design and architectural offices are non-residential in nature and have not been approved or permitted by the city of Charleston. The board failed to consider the third reason for the appeal. The board failed to consider the impact on the portion of 60 Church Street at the rear or east property line of 62 Church. Ms. Melhado and Mr. Neller were unable to testify. Had they been able to testify, they would have been able to clarify the Wallace's misstatement that Ms. Melhado and Mr. Neller are to their south and all shadows are cast to the north. We believe the board was confused as to the extent of Ms. Melhado's property, the impact of the Wallace's requests would have on the rear of 60 Church Street. In fact, board member Grass inquired as to who the property owner was at the rear of the Wallace's property, and the Wallace's failed to clarify that it was in fact Ms. Melhado. The board, we believe, was again confused as to the ownership of this real property, the rear property, and that's significant because as to the impacts on light, air, noise, and fumes, all specific elements of 54.110F are most damaging to 60 Church Street along the rear of the property where their pool and pool house are located. If the board had allowed their testimony, these impacts and harms resulting from the approval of special exception and variance would have been better understood by the board. We believe a different result would have likely ensued. Furthermore, number four, the fourth reason for our appeal, the board permitted the applicant to provide language for the motion of the approval. Neither 629-800A2D Romanet 2 nor section 54.110F provide that an applicant can provide the language as to the conditions for the motion for approval or for the motion for approval. And we believe the board improperly delegated these powers to the applicant, Mr. Wallace, to create an ambiguous self-serving condition related to the approval of the variance and special exception. There is no provision in the enabling statutes or the zoning ordinance that allow for this delegation of power, and consequently we believe this delegation was an error of law by the board. Fifth, the board misapplied the variance test as required by South Carolina Code section 629-800A2. In their response to the second statutory requirement for a variance, the Wallaces claim that 62 Church Street is, quote, much smaller than neighboring properties. However, this claim is clearly and unequivocally rebutted by the Wallaces' hearing testimony and their exhibits, which clearly show the opposite to be true. The Wallaces provided numerous exhibits in addition to their hearing testimony. One of those exhibits was a map that showed the lot sizes and lot coverages of a number of properties in the vicinity, notably 62 Church Street at 4,795 square feet was larger than 50 Church, 52 Church, 54 Church, 66 Church, 68 Church, 70 Church, and 72 Church, and only slightly smaller by just a few feet than 55 Church and 64 Church, all properties that surrounded 62 Church. While the Wallace's response states that their presentation demonstrated that this property is much smaller than the neighboring properties, this claim is evidenced by the Wallace's own hearing testimony and exhibits as false. As the second part of the statutory variance test has not been met, my clients believe the board erred in its approval of this variance request. Lastly, the sixth point of their appeal, the board misapplied the special exception test as required by ordinance section 54.110F and South Carolina Code section 629-800A3. As set forth earlier, given the proposed expansion includes an enlarged office and that neither Mr. Wallace's architectural firm nor Ms. Wallace's interior design firm have been approved by the city of Charleston for home occupation uses, either by application or business license, the board erred as a matter of law when it determined that the physical extension of the non-conforming use is limited to extending or increasing the non-conforming use then in existence at the time of adoption of 54.110 of the zoning ordinance, as 54.110F requires. Furthermore, as explained in section, as explained earlier today, the board understood the impacts. The board understood the impacts of Ms. Melhado's property, which you can see in the display that Mr. Batchelder has up. that Ms. Malhado's property is L-shaped and surrounds the rear, it surrounds and goes back to the rear. You can even see the shadows that are cast in this picture from the county assessor's office GIS map. Had the board understood the impacts to the rear of Ms. Malhado's property as to light and air, as the shadows show, noise and fumes, as the air conditioner, compressor, and generator will generate, each specific elements of 154.110F, light, air, noise, and fumes, we believe a different result would have ensued. And so for the 6 reasons that I just went through, we believe that the board erred and that this matter should be remanded or sent back, go back to the board, if you will, for a rehearing.
Thank you very much. Is that it, Mr. Hillman?
That is, yes.
Staff, is that a 10-minute time period elapsed?
Yes,
No.
it has elapsed
Oh, it has. Okay. As of
yes.
right now, huh?
as of right now.
Yeah. Okay.
Thank you very much. Is there opposition to this application?
Yes.
y-
Mr. Turnham Walker, I think is,
Yes, he has.
Mr. Walker present?
he is present. And okay, Mr. Walker, can you hear us?
Thank you. Can you hear me?
Yes.
Mr. Walker, would you please allow Mr. Batchelder to swear you in?
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please
And
proceed.
let me see if I can get the video going. My apologies. I don't see the button. I'll
Oh,
proceed nonetheless. I'm Turnham Walker here with Jennifer Ivy on behalf of Skip and Erica Wallace, who own 60 Church Street. We are not going to have a long presentation in opposition because it is clear that the applicant and opponent has not met the very high bar for rehearing. The matter before you is whether or not the standard has been met for a rehearing, which requires the board to find that it misapprehended or misconceived the question or questions involved, or that it erred in its finding or disposition of the appeal, application, or matter. All of you know that there was no misapprehension or misconception of the issues. The issues were presented by both sides, exhaustively discussed. The motion was made and passed. The board correctly applied the test. And what's happened is that the opponents are using this request for a rehearing to re-argue the merits, which is improper. They haven't shown any misconception. What they've done is to shoehorn their arguments into their motion to make them one more time. Briefly going over their grounds, the first one dealt with the failure of Ms. Malhado and Mr. Neller to testify. The opponent was given 10 minutes. The opponent chose how to use those 10 minutes. Mr. Hellman spoke. There is nothing that Mr. Hellman said that would in any way have been different if those two had testified. He covered everything. So there was no procedural deprivation. The requirement is that the opponent has an opportunity to respond, and the opponent had that opportunity. As for commercial use, there is no commercial use. I think you heard that Mr. Wallace has an office in the Confederate home where he practices, to the extent he does, his architectural practice. And Ms. Wallace has a small office with no windows in the house where she does some work in her interior design business, but it's largely conducted on site out of her house. There was no proof of anybody driving up to the house. What she has is effectively a home office where she does receive mail for her business. She has no other office, but that does not convert the property into commercial use. After the hearing on September 7, she proceeded to make her application, and she does now have her business license, and she is in full compliance with the ordinance. The whole issue, though, is basically a sideshow that doesn't have to do with the test applied by the board. As to the impact on the back, I think you saw in the photograph that was attached to the response that was filed today, the rear of the Wallace's property abuts a stand of large, fully mature trees and bushes, so that there's a complete opaque screen. Any alleged shadow from the house is not going to fall onto the Wallace's property. The shadows are caused by the trees that were planted many years ago. Again, that has no bearing on this. Also point out that they were talking about their pool house. As far as the owner suggesting conditions for approval, the board had complete discretion to say, we don't agree. There's nothing that prohibits the board from getting a suggestion, and there is no prohibition on an applicant working out conditions with staff. It happens all the time. I can't tell you the number of instances where conditions were agreed to in discussions with Mr. Batchelder that were presented to the board, and the board approved them, but the board isn't required to do that. The board has a mind of its own. If it didn't like the condition, it could have changed it. There was no misapplication of the variance test. If you look at the diagram that Mr. Batchelder put up at the beginning of this presentation, you'll see the size of the Wallace's lot in comparison to the ones around it. But it's not the size of the lot in particular that makes it unusual. As was stated at the hearing, it's the fact that the house is set back so far from the street. That means that the only place in the small addition can go is on the back. And the last thing was enlarging the office. There is no enlargement of the office. Ms. Wallace has her office upstairs in a room. If she were to move and use some other part of the house, that's not an expansion of her quote office. She can go anywhere she wants in the house. That again is something that is not pertinent to the decision that was made by the board. What we have is a replay of what you heard 5 weeks ago, packaged a little differently. We would submit to you respectfully that the high bar for a rehearing has not been met. Thank you, Mr. Chairman and board members.
Does Mr. Walker have any more time?
I show 6
Yes,
minutes.
Mr. Robinson, he does. He has about 5 minutes. Well,
Mr. Walker, does that complete your presentation?
It does, Mr. Robinson.
Okay.
The scope, as I understand it, of this is simply to respond to the motion itself or the application for rehearing as opposed to the merits. I think the board has it, so I'm not going to belabor what I've already said. Thank you for the opportunity.
Thank you. Mr. Hellman, in rebuttal, 3-minute presentation.
Thank you, Mr. Chairman. So I'll keep my rebuttal brief, specifically as to the misapplication of the variance test. As Mr. Walker pointed out, he said what's different about this property is the way it's set back. But the issue with the variance test isn't the setback, it's the lot coverage ratio. And as to the lot coverage ratio, the argument that was made was it was much smaller than neighboring properties. The fact is, it's not. And so therefore, given that it's not smaller than all these neighboring properties, as we've pointed out, and as their own exhibit shows, that second prong of the test, that these conditions do not generally apply to other property in the vicinity, just can't be met. And all of the elements of the test have to be met. Secondly, as it relates to the special exception test, the importance of these commercial uses is 54.110F says that the non-conforming use, if there's going to be a physical extension, must be limited to extending or increasing the non-conforming use then in existence at the time of the adoption of 54.110, the zoning ordinance. There was no request for a change in the non-conforming use. There was merely a request to extend or increase the non-conforming use then in existence at the time of the adoption of 54.110. And as Mr. Walker said tonight, Ms. Wallace just applied for a license for this other non-conforming use, this interior design commercial use, which is a different use. That's the first prong of the test. And again, we don't believe that it was met and that the board misapplied the test and misapprehended the question. And with that knowledge, and with the knowledge of the Melhado's property going to the rear, as Ms. Grass had asked that question specifically of the Wallaces, that the light, air, noise, and fumes, the second prong of the test, if those were applied, we believe a different result would have ensued. That concludes my presentation. Thank you.
Thank you very much. That concludes the public hearing portion of the meeting. And now we'll open for the board any discussion, any questions of anyone, any comments, any motions.
I have one question to start, please, Mr. Robinson. My recollection is, and it may be wrong, that Mr. Walker's comment that Mr. Hellman used up the full 10 minutes is what in fact happened, but I wonder if we have any record of that, or if anybody has any clear recollection or notation of that. This, of course, goes to the suggestion that we accidentally prevented two witnesses signed up to speak from speaking.
It's my understanding the city did listen to the tape and verify that, Mr. Morrison. I'll ask Mr. Batchel if that's correct.
I'm going to refer to Ms. Ashby on this question. I don't recall exactly what the time was. I think my start time on my timer was a little off that night. I didn't quite get it started at the beginning of his presentation, but Ms. Ashby, do you have any?
When Mr. Batchelder, when I listened to the tape, Mr. Hellman had used the entire 10 minutes allotted to him, with no further mention of anyone else wanting to speak at that time. But the 10 minutes that were allotted to him to speak, he did use those minutes.
Mr. Batchelder, just thank you, Penny. I presume Mr. Hellman is correct that once his time is up, the way the Zoom process works is he's effectively unable to communicate anything further by virtue of how the technical aspects work.
That's correct.
Okay.
Any other questions, any comments from the board?
I believe that we did discuss, correct me if I'm wrong, the impacts to the rear property, did we not? I mean, was that discussion omitted from that meeting?
Would you please repeat that, Ms. Richards?
thought I remember that we did discuss the effects to the rear of the property.
I thought we did also, and I do recall that there was a slide that had extensive drawing on how the light would fall. I don't know if fellow board members remember that, but I do believe it was for this application.
I certainly realized it was an L-shaped lot next door.
Yeah, I realized that too. And I thought that we sort of were discussing the effects on on the entire property, not just the north, south.
That was my understanding as well. And I recall as well, a sun study, some sort that was presented as well.
And I did mention, as Mr. Hellman said, I did mention that the issue of the so-called commercial use of the property was not properly before the board. We're looking at a variance and a special exception. So for other reasons. Any other questions, any comments? The board is familiar with the statement. I think it's been mentioned a couple of times already in this case. It's in the case of an appeal for reconsideration of a board decision, applicant, who is Mr. Hellman, shall state below the grounds upon which it is considered that the board misapprehended or misconceived the question or questions involved, or the ground or grounds upon which it is considered that the board has erred in its finding or disposition of the appeal, application, or matter. So that's what we're here tonight to decide.
Mr. Chair, would you repeat? I apologize. I caught the misapprehension and misconception of the question. I didn't catch the third condition.
Are the ground or grounds upon which it is considered that the board has erred in its finding or disposition of the appeal, application, or matter.
Thank you.
Addressing another one of Mr. Hellman's points, number 5, that we misapplied because the Wallaces had claimed that their property is much smaller than neighboring properties. I just don't recall for myself that being a factor one way or another in my decision in September.
Mr. Morrison, I think, please correct me if I misstated, but I think we considered it due to the fact that the house sits so far back from the street, and the front yard has a very nice garden, and that leaves very little backyard to go. So that the area where an addition can be made has to be in that backyard, which is much smaller than many of the other backyards. Maybe not the entire lot itself, but the area where an addition may take place.
Yeah, and I remember that. And what I meant, I wasn't very good describing this, but what I meant was, I don't recall relying on any suggestion by the applicant, by the Wallaces, that the totality of their lot or the size of their lot, the total square footage of their lot, was much smaller than the neighboring properties. That's the way it has been put to us, I think, in this application for rehearing. But I think what we talked about was what you recall. I do remember considering that.
Mm-hmm.
I agree with that too.
Mhm.
Are there any other comments,
I'll just add
questions,
one.
motions?
I'll just add one additional comment too, and that is the suggestion of a comment. I don't believe is a delegation of our authority or our power to the applicant. Excuse me, when I say comment, I mean condition.
And I agree with that. We were talking about the same topics as a group,
Mhm.
and all of us on the board had to concur with the wording, whoever articulated it, of the special condition, which we did.
Mhm.
There are only so many ways to word a specific thing. And I wrote that, you saw my handwriting, I wrote it at the end of the meeting and just recollected use the language that I thought best suited what we had talked about. So I think we did the best job, and if it happened to coincide with what the applicant had said, that a lot of that was just mere happenstance. Questions? Comments? Motions?
I'll move to deny.
That was Ms. Vargas.
Yes, sir.
Thank you. Move to deny the reconsideration. Is there a second?
I will second that motion.
Seconded by Mr. Bennett. All in favor signify by saying aye. Mr. Morrison,
Aye.
Ms. Grass,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett,
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much.
Mr. Robinson, did you say the motion is approved or disapproved? I
The
mean,
motion was
the motion
approved.
is approved for denial.
For denial, correct.
Okay, all right, thank you.
Next item on the agenda is 44 Collins Drive, Burnsdown. Request special exception under section 54-110 to allow a vertical extension, second story addition, to a non-conforming building footprint, having a non-conforming 6.8 foot north side setback 9 feet required, zoned SR2. Mr. Batchelder.
Okay, so this is a residence in Burns Downs. And this map shows its location backing up to Coburg Road. Property has a residential zoning like the surrounding properties, SR2. This aerial view shows the house. It's a one-story house. And which is very typical in that neighborhood, built probably in the 40s, I believe, and small. And the proposal is to expand the house, which is something we're seeing more of with Burns Downs homes. And you'll see some slides in here of some homes where we have approved those expansions, and they've been done very tastefully. So the house, like many homes in Burns Downs, does not meet all the setback requirements. Of course, those homes were built before the city had any zoning in that area. So in this case, you've got a house that has a 6.8 foot north side setback, as shown here on the survey. Here's a site plan. So I'm going to turn this laser pointer on, but the red dash lines illustrate the required setback requirements for that neighborhood. And the house footprint, as you can see, encroaches on the north side of the lot. So what they are proposing to do is build an addition. Let's see here. I go here. Okay. So again, in this blue outline, blue dashed line here, this is the footprint of the existing home. And then you see the proposed addition shown here comes off, hugging that side property line or that setback line on that side, and extends into the backyard as well. But this element of the house goes up vertically. So here we have the existing on the bottom and proposed floor plans on top. Existing first floor. You see the reconfiguration of rooms and the addition. And it's the second floor that is brand new being added. And so it's basically this section of the home right here that requires this special exception for the vertical extension of the non-conforming building footprint. Roof plan, elevation existing on the bottom, proposed on top. Very nice design, very much in keeping with the homes in Burns Downs. Side elevations, this is a south side. And then this is the rear and north side elevation right here, which is the elevation that would be within this element here would be within the setback. The applicant has provided an indication from the neighbor on that side of the property. The neighbors at 42 Colleton indicate that they support this request. This is just photographs. I think this is an old photograph of the house. It doesn't look like this today, but this is the house. Here's another home where a vertical extension was approved by the board and constructed. Very nicely done. This is an alteration. I can't remember exactly what kind of approvals were necessary here. Another rear addition looks like, and possibly this carport, although that looks to be old. And another home that's being approved. So I think this proposal meets the special exception requirements, and I recommend approval.
City recommends approval. Ms. Ashby, is there any opposition?
No, Mr. Robinson, no opposition.
Mr. Morrison moves for approval. Ms. Grass seconds. All in favor signify by saying aye. Mr. Morrison,
Aye.
Ms. Grass,
Aye.
Ms. Richards,
Aye.
Ms. Vargas,
Aye.
Mr. Bennett.
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Item number 4, 14 Campbell Drive, Burns Down. Request variance from section 54-301 to allow screen porch addition with a 6-foot west side setback, 9 feet required, zoned SR2. Mr. Batchelder.
So another home in Burns Downs. This one located on Campbell Drive is shown here. The home has this 1-story addition, small 1-story addition right now. That would be replaced by a new screen porch. And zoning map application here. Information from the applicant explaining their situation. And one thing about this photograph, you see these 2 very large grand live oaks at the back of their property, and the protective areas around those trunks where you don't want to build anything because you'll damage the roots is quite large as a result of those 2 large trees back there. So that begins to limit what they could do in the backyard, but also the layout of the home doesn't lend itself to a rear screen porch. It would have to be accessed through the bedroom. So they've proposed removing that one-story element over here and building a larger porch back in its place that would come over to this dash line right here, which is a 6-foot setback off the property line. In the survey, this is the proposed screen porch, 6-foot setback over here. There's still plenty of room for parking on the lot, so that's not an issue. And this is a drawing here. So they talked to the neighbor next door, and this is the neighbor at 16 Campbell on that side of 14 Campbell, who would be the most impacted by this addition. And they indicate with this letter that they support this variance. So I believe they meet the variance test. Again, the layout of the home and the trees create a hardship, and so I recommend approval of this application.
City recommends approval. Ms. Ashby, is there any opposition?
No, Mr. Robinson, no opposition.
Ms. Grass moves for approval, second by Ms. Richards. All in favor signify by saying aye. Mr. Morrison?
Aye.
Ms. Grass?
Aye.
Ms. Richards?
Aye.
Ms. Vargas?
Aye.
Mr. Bennett?
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Next item is 30 Ray Street, which has been deferred. Following item is number 6, 11.5 St. Philip Street, Charleston Village. Request variance from section 54-301 to allow 2 dwelling units, duplex, with 1,760.5 square feet of lot area per dwelling unit, 2,000 feet required, zone DR2F. Mr. Batchelder.
11.5 St. Philip Street is an interesting property. It sits just south of Wentworth Street on the west side of St. Philip Street in Charleston Village. It's zoned residential, so you see the brown shading on the property indicating it's residential zoning, which is consistent with the neighboring school, Meminger, and that's it. The properties to the north are commercially zoned. Property across the street, which is that parking garage on St. Philip at Wentworth, that's commercially zoned. But this property has a residential zoning. Now, it did not contain a residential structure. This is a image from 2014 showing the structure that occupied this property for a long time. The property, 11.5 St. Philip Street, was part of the Meminger property, and it was owned by the school district. And the historic building shown here was allowed to deteriorate. And, the school district didn't have the money to take care of the issues with this building. And finally, there was interest in somebody buying this property and trying to make some sort of adaptive reuse of the building happen. And we were hopeful that would happen, but the building proved to be in very poor structural condition. And at some point within the last, I think, couple years, the building collapsed. So it now looks like this. So most of the building is gone, but the facade on St. Philip Street still exists. The BAR, I don't think will allow that to be torn down. And you can see it's been stabilized as well as the north wall. And so the plan is to build back a new structure and incorporate that facade. But the the use that was originally planned, which was office, is no longer a viable use. And so the applicant would like to have the ground floor be office, but the upstairs be 2 residential units. Now, the lot size does not allow 2 residential units. It's not large enough under the zoning of the property to permit 2 residential units. And by the way, the parking issue is not an issue because that was the reuse of this building was approved a number of years ago without there being any parking. Those approvals have been granted because there simply is no parking on the site. The parking you see here is on the Meminger property, and it's the school district's property. But there is that large parking garage right across the street. This building, because of its size, is not going to generate a lot of demand for parking. So we didn't think that should be a roadblock that would prevent the property being restored. So that's not an issue. It's just simply the use of the building. And another view of the property as it exists today. The proposal is shown here. So on the ground floor, you see an office in front, an office space in the back, labeled office A and B. And by the way, this building footprint, I think, is pretty much matching what was there. And then on the second floor and third floor, you'll see that there's residential units. So 2-story units, living space on the second floor for each unit, and then bedrooms up above on the third floor. So that's the proposal. Of course, this will have to go through the BAR and receive their approval as well. But this is a proposal for restoring the facade, tying it back into a new building on the site, and making use of this property, which has been vacant and unused for many years. And one other thing I think that's worth pointing out is that, of course, with residential units, you're going to have parking demands in the evenings and weekends, certainly, with the people who reside there wanting to park their car somewhere in the area. And I think that those issues could be worked out somehow. There are other apartments nearby, King Street, for example, that have no parking, and people seem to figure out solutions to those issues. But the important thing is that this property is not within the Charleston Village residential parking districts, which are shown here on these maps. The blue is one area, and the I guess that's sort of a pink color. That's a different parking district, residential parking district. So the properties that are within those districts that are, I guess, residential properties have the opportunity to purchase decals to park on the streets. But this property, being where it is not within one of those districts. So it would not, residents would not have the opportunity to buy decals and park in the neighborhood and impact those people. So that is my presentation. I recommend approval of this request. I think it's very reasonable to place a mixed use back on the property, and residential units on the second floor. With the size of the building, I think it lends itself to being 2 units rather than one really large unit. So for those reasons, I recommend the approval of this request.
City recommends approval. Ms. Ashby, is there any opposition?
No, Mr. Robinson, no opposition.
Motion for approval is made by Ms. Richards, second by Ms. Vargas. Vargas, all in favor signify by saying aye. Mr. Morrison.
Aye.
Ms. Grass.
Aye.
Ms. Richards.
Aye.
Ms. Vargas.
Aye.
Mr. Bennett.
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Thank you very much. Next item is number 7. Mr. Bennett will recuse himself from this item. 82 Mary Street, Mezquite, Ragsboro, request special exception under section 54-220 to allow a 50-unit accommodations use in MU-2/WH mixed-use workforce housing zone district. Mr. Batchelder.
So this site is a property that's been in front of the board before. This area map will refresh your memory maybe, but this is the Hughes Lumber, former Hughes Lumber location on Mary Street that runs all the way through to Reed Street. And going back a few years, and I'll just mention that I've got a few slides up front that I'll present, and then all of the materials that were submitted by the applicant, all their slides, all the information follows my presentation. So just to let the applicant know that. But this map shows the location going back to, I think it was 2017, maybe early 2018. There was a proposal for a 8-story office building. Sections of that office building were actually approved to be 9 stories by the BAR, as is their right, but they received and approved a request for a very large office building and parking garage on this property. And that proposal didn't work out. And then going back about 2 years ago, I think it was 2019, perhaps it was early 2020, the board heard a request for converting that proposed office building that had BAR approval, the office building and parking garage, converting that into a 250-unit hotel. And at the time, the board denied that request. And so that project went away. And now a new proposal has come forward. New developer is bringing this forward. And they would like to construct a mixed-use development on this property, residential as well as 50 hotel rooms. So here's the property today. Most of the buildings have been demolished. The historic building on Mary Street right here, the 2-story element, that still remains, as do parts of the other building there. But it's the historic 2-story section of this building with that gable roof that the BAR said cannot be demolished, has to be reused somehow on this site. And it was going to be reused with the office building, and you'll see how this application proposes to reuse it as well. Zoning of the property, mixed use to workforce housing, it's in the accommodations overlay zone. And the applicant has submitted all this information in response to all of the requirements for a special exception for an accommodations use. And I've reviewed it carefully and determined that I think they meet the special exception requirements. So my recommendation will be for approval. But before I get to that, I just want to go through a few things from this. So there's no residential on the property. So there's no displacement of residential units that needs to be considered. There's no office use on the property. There is the retail use from that building, but that storefront retail space is not going to be eliminated. It will be recreated in the new building, and the historic building that will be retained. And I'll go through the traffic report that we received for the traffic recommendation we received from our Department of Traffic and Transportation, and go through these other things, but I just want to hit the highlights here on these plans. So the parking will be provided underground, and this diagram shows how they could lay out the spaces to meet those requirements for not only the 50-room hotel, but also the 78 apartments that are proposed on the site. This site plan shows the relocated historic building, which is, of course, subject to the approval of the BAR. They will ultimately decide if this location is acceptable. And if it's not, then alternate locations will have to be considered. But this is a proposal for the ground floor. The hotel would be on the south side of the site along Mary Street. You see the passenger loading and unloading zone right here in front. And retail, meeting space, restaurant space here, and then back of house functions over here, more retail over here. And an important feature of this plan is that this site, this proposed development, along with the adjacent hotel at 411 Meeting Street, will provide an opportunity for the low line public space here along the property line between those two properties to be created for an extension of the low line. Right now, there is no low line across either one of these properties. It's private property, and the proposal as shown here would create a very wide section of a public park, basically running between Reed Street and Mary Street to extend the low line that will exist to the north and extend the low line that does exist to the south. These are just more drawings. So this shows the rooftop of the hotel. The apartment building would be the full 8 stories that is allowed by the height district in this area. But the hotel is not 8 stories. This is, I guess, would be 4 stories tall, and the rooftop on top. And although there's access shown, the proposal does not propose to make this any restaurant or bar space or event space. So that is not part of this plan. It is simply potentially, I guess, accessible to hotel guests as an amenity space. And then you see the rooftop of the apartment building, which has its own pool and outdoor space for the residents of that apartment building. This is a drawing that was included by the applicant just to illustrate the total conditioned floor areas of the hotel and the remainder of the property, which is apartment use. And this is used to calculate the 12% maximum restaurant bar space that can be placed within the hotel facility. And as you can see on these calculations here, they've met that. They're at 11% of the total floor space of the actual hotel facility. So, and they've indicated the spaces that they are counting towards the total conditioned floor space of that facility. So there's no issue there. And again, this is just an illustration I've made to show how 411 Meeting Street, that property, and the 82 Mary Street property butt up against each other right now. And at some point, I guess there was a railroad line coming through this block, but the railroad, I guess, sold that property to one or both of these property owners back then. And so there is no opportunity for a public passageway between Reed and Mary Street, but this proposal will create that. And this is just an image that the applicant included with their package showing this is the courtyard that they are proposing to construct, and that historic building would fit somewhere in this courtyard potentially. This is the residential apartment building back here. Restaurant would be back here. This would be retail and meeting space on this end, and this would be, of course, the low line and the backside of 411 Meeting Street right here along that low line. So together, these two projects can create something really special in that block. And so the James Wallace, who's our traffic operations manager with the Department of Traffic and Transportation, has reviewed this traffic study and determined that he's fine with the proposal and the guest drop off and pickup area. And we received this position statement from the Preservation Society, Aaron Minigan, indicating that they're, I think, supportive of this request, or at least not objecting to it, that they see value in the things that they're doing with this proposal, creating the mixed use and creating the low line space that doesn't currently exist. So with that in mind, I'm going to recommend approval of this request. I feel that it satisfies the special exception requirements and achieves a mixture of uses on this property, not only on the property, but helps to do that in the general area by creating this low line piece and drastically reducing the number of hotel rooms that were proposed on this property. So, so that's my recommendation.
City recommends approval. Ms. Ashby, is there any opposition?
No, Mr. Robinson, no opposition.
Ms. Vargas moves for approval, seconded by Mr. Morrison.
And I would like to just say that I would give, because I'm sorry, I should have mentioned this before, but because the special exception standards are so extensive for a accommodations use, I would like to just give Mr. Wallace, who represents this application, the opportunity to add anything that he would like to add.
I had one question, Lee.
Okay.
With regard to the parking spaces, so the parking spaces were enough for the apartments and for
Right.
the hotel accommodation. So the parking was completely taken care of. Is that right?
Correct. That's correct.
And I had a quick question too before we move on. You may have mentioned this, but I just want to make sure the apartments are for long-term rental.
That's the proposal. Yes,
Okay, thank you.
yes.
You wanted to introduce someone, Mr. Batchelder?
Well, James Wallace represents the application. And I always like to invite the applicants for these accommodations uses to go over anything that they want to also put on the record as part of the hearing. So if we can promote Mr. Wallace. I mean, Wilson, I'm
Mr.
sorry,
Wilson.
James Wilson. I'm sorry. Getting confused. Okay, very good.
Mr. Wilson, are you present? Mr. Wilson?
Mr. Chairman, I'm here. Yeah, James Wilson.
Would you please allow yourself to be sworn in by Mr. Batchelder?
Of course.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please proceed.
Thank you, Mr. Chairman, members of the board. I'll be very brief since Mr. Batchelder has obviously done a good job already giving a good description of the project. I only want to speak just to make sure that we've hit the criteria because they're so specific for the record. And so I'll try to very quickly do that. The key points I think really are what you already have heard, which are that we think this is a great proposal for this property. It's a true mixed use project. It's much smaller than the previous ones, the 250 room hotel proposal and the much larger office. The hotel is really only about a third of the overall development. And the accommodations test really tries to emphasize preserving and growing retail and residential uses. And we're actually adding a lot to both of those. And then of course, really the highlight of this project is the low line in that public space that's being created. As you know, Mr. Bennett owns the property on both sides and is creating space for the low line that'll be very wide and it'll have tremendous, as you've seen from the plan there, a large courtyard on this side, but there's also a large plaza on the Meeting Street side that you can't quite see here, which creates a tremendous large open space that's pedestrian oriented. It's lined with retail and restaurants. And so we really think this is something special being created. We've of course been in touch with the neighborhood and the Historic Charleston Foundation and Preservation Society. Overall, we think most people are just very excited about this proposal and what we're doing. That said, I'll just very quickly run through the criteria, as I said, just to make sure we've got it on the record. I'll hit these quickly. There's no dwelling units are being displaced. No office space is being displaced. We're actually increasing the storefront retail space all along the low line and a piece on Mary Street. We're not increasing any automobile traffic in residential neighborhoods because you don't need to traverse any residential neighborhoods. You have good access from King and Meeting here. We're clearly contributing to a diverse mixed-use district. We're staying within the 12% limitation for restaurant and bars, of course. The guest drop-off and pickup area has been reviewed by James Wallace, Inspector James Wilson, at the Department of Traffic and Transportation, and they are satisfied with that. We of course meet the minimum 10 sleeping units, and we are staying within the A1 zone 50 hotel guest rooms for this area. This hotel will not share any of its building structures, facilities with any other accommodations use. Will include at least 2,000 square feet of conference meeting space to meet that required ratio. This will not result in there being more than 8 full service hotels on the peninsula because this will not qualify as a full service hotel under the test. And of course that as part of this hotel, like any new hotel, there'll be a contribution to the city's workforce housing account. Running then through the other criteria to be considered, we've already touched on dwelling units and office space and storefront retail. The guest drop-off and pickup, as we've discussed, is right along Mary Street. The vehicle trips generated, there's a traffic memo that was submitted as part of the application. The short of it is that this generates about a third fewer vehicle trips compared to the approved office building. We have good access to arterial roads, King and Meeting Streets. The land uses within 500 feet include the car to bus station, parking garage, retail, businesses of various sorts, restaurants, offices, multifamily, and we've listed other hotels in the area as well in the application. The proximity of residential districts, the nearest ones would be Nassau Street or St. Philip Street, and those are not impacted by this proposal. the accessory uses here are really retail and restaurant. Those are compatible with what we're doing, and we fully meet the parking for all of the proposed uses and have additional parking spaces as well, some of which can be used for employees. That covers parking on the, there's no industrial use is in the neighborhood. Our client, of course, is committed to environmental sustainability. We're within walking distance of most major attractions on the peninsula. We're close to public transportation. The no shuttle bus services required in this district. And my client, of course, will continue as he has done in the past to make good faith efforts to try to engage MBs and WBEs to do the work and to have a good representative group from Charleston working at the project. In short, we do believe all these criteria are satisfied. It's a real mixed-use project here, which we think most people understand it is a much better proposal. We've got shops and restaurants lining the low line, a tremendous new public area there that creates a real gathering place that's not on the streets. And of course, you all know my client, Mike Bennett, who the city has come to know and expect high quality projects from. And so with that said, we respectfully request approval and are glad to answer any questions. Mike Bennett is actually on the call as well, as is Tracy Ray. So if you have any questions, we're certainly glad to answer them. And thank you for listening to us.
Thank you, Mr. Wilson. Any questions for Mr. Wilson? I think we've gotten ahead of ourselves a little bit. Ms. Ashby said there's no opposition, and Ms. Vargas is prepared to make a motion for approval, and Mr. Morrison is prepared to render a second. All those in favor signify by saying aye. Mr. Morrison.
Aye.
Ms. Grass.
Aye.
Ms. Richards.
Aye.
Ms. Vargas.
Aye.
Mr. Robinson votes aye. The motion is unanimously approved. Looks like a wonderful project. Good luck.
Thank you so much.
That concludes the meeting. Thank you, everyone, very much.
Yeah.
Thank you.
Thank you, everyone.
Everybody.
Good evening,
night.
everyone.
Bye, everyone.
Okay. Have a good
Everyone.